today to talk about the summary conviction trial process. This is a process that applies to basically all summary conviction trials in Ontario. It also applies to indictable matters. If you're having a trial at the Ontario Court of Justice, I will not be discussing preliminary hearings or jury trials. But the vast majority of cases in Ontario are dealt with at the Ontario Court of Justice by way of trial. And at the very start of the case, a decision has to be made, and that decision has to be made by the Crown. This is a diagram that I've used for years and developed for years to sort of explain to clients a little bit about the trial process. So this is a decision box, and the first decision is made by the Crown. In every single case in Ontario, there's a process of charge screening where the Crown will review from the very start whether they're going to proceed or not. So the Crown has a choice to proceed. You have to make a decision. It can be yes or no. If the Crown decides not to proceed, the case is over, and there's no criminal record. Now, you're going to ask me, well, Craig, how do we convince the Crown not to proceed? Because that's the best way to go. Well, there's two ways. Number one, we can try to convince the Crown there's no reasonable prospect of conviction. No reasonable prospect of conviction is a legal test that's applied by the Crown to the anticipated evidence. There is a second way. The second way is to convince the Crown that it's not in the public interest to proceed. And essentially what we're doing there is we're saying to the Crown, look, despite the fact that you do have a strong case, it's not in the public interest to proceed, and here's why. There's a variety of charges that fall into here. So for example, minor theft charges are dealt with by way of diversion. If people get a little bit of counseling, sometimes they have to make a donation. Some domestic cases are dealt with through counseling and peace bonds. As well, there are many mental cases involving mental health issues, where it's much better for the accused, the victim, and the community at large that the accused get help through mental health help, through counseling and all that in the background, and for the case to be taken out of the court process. If you recall the Gian Gameshi case in the spring of 2016, you recall that Mr. Gameshi did some effective counseling to address some of the issues that landed him in court, and then he signed a peace bond. And the Crown said that having regard to the good work that he did in counseling, and having regard to the peace bond that was signed that day in court, they're going to withdraw their case and have the case over, and that it's not in the public interest to proceed. If you go back and Google that and check there, you'll see that the Crown never said they had no case. But let's assume for the minute that the Crown's looked at the case and they're going to proceed. Well, if the Crown proceeds, then the accused person has to make an important decision. The accused has to decide what's going to be their plea. Do they plead guilty, or do they plead not guilty? Well, if you plead guilty, then you're going to be sentenced by a judge. Now, I can't explain all the aspects of sentencing, but depending on your case and what you've been charged with, it could involve debates about whether you should be convicted or discharged. There might be jail involved. There might be fines involved. There might be probation. And there could be a variety of other orders, such as firearms orders and Section 161 orders and all of that. That's all part of sentencing that will depend upon the particulars of your case. Let's just say that you're the accused person now and you want to proceed plead not guilty. Well, if you're pleading not guilty, then you're going to be headed to trial. And it's important to think of the trial organically. It's a process that's going to unfold over time, from the start of the trial to the end of the trial. There's really two processes that are happening, and both are processes of uncertainty. So the first process is, how will the evidence unfold? And no matter how prepared both the Crown is and the defense is, there's always some uncertainty about that. There's always going to be some surprises there. If you think back to the first Gameshi trial, I don't think anybody fully anticipated exactly how all that evidence was going to unfold. The second thing that will determine what happens at your trial is how the judge reacts. Again, these are two processes of uncertainty. So no matter how strong the case, there can always be problems with respect to how the evidence unfolds or how the judge reacts. Okay? And who's going to be now at the trial? Of course, there's another important decision box. And at the top of that decision box, there's the judge and how will Her Honor find. That's the question here. Will Her Honor find you guilty, in which case you're going over here to be sentenced, or will you be found not guilty, in which case you're back here and your case is over and after the appropriate waiting period, you can apply, and you have no other criminal record, you can apply for your Prince instructions. Now, you see this diagram kind of explains everything and the decisions that have to be made along the way. But I'd like you to think of this as the left side. This very left side is being the trial, the pre-trial process, and this over here being the trial process. So I want you to just think of this. And in our system of justice, we don't plead guilty or not guilty until the very start of the trial. So the pre-trial process technically, that lasts right until, you are called upon to plead guilty or not guilty at the start of your trial. And there's three things that are happening during the pre-trial process, okay? So one is you're receiving the disclosure. That's all information documentation on the case that you and your lawyer are receiving to review the case. The second thing that's happening is that you're attending for set dates. There's always a court date until the case is over. And you'll hear this term set date, but all the set date really means is that on that date, we're just going to set another date. And then the third thing is there's a series of pre-trial meetings with the Crown and sometimes with the judge. So if it's a meeting with the Crown, we call that a Crown pre-trial, and if it's a meeting with the judge, we call that a judicial pre-trial. And what we discuss about at these pre-trials is in fact these issues here. Is there any reasonable prospect of conviction, whether or not it's in the public interest to proceed, and if the Crown does proceed, then we're talking about how much time is needed for trial. But essentially these pre-trials are my opportunity or a lawyer's opportunity to try to convince the Crown not to proceed. Once you have all the disclosure and we're ready to set a date, the time that's needed is approved by the judge, then the date is set. And then we're doing something that's very important, but it's kind of torturous in its own way because nothing happens during a long period of time while we're waiting. We're just waiting for the trial to come around, and that could be anywhere from 4 to 12 months, depending on where you are in the province. There are significant delays. I draw the diagram like this because the decision to plead guilty or not guilty, that's not done really until the morning of the trial. And by the time we reach the trial, it may give me an opportunity to go back and look at both of these issues as well. Because, for example, if I show up at the trial and there are no police witnesses there, then the Crown's case is severely compromised, and I may be able to convince the Crown on the very morning of the trial, look, you have no reasonable prospect of conviction because the law has changed, or because you're missing a witness, or because this document is lost, or because some important exhibit on a drug trial has been lost. Or there may have been something happening during this pre-trial phase while we're waiting for trial that might cause the Crown to believe that their case is not in the public interest to proceed. So, for example, in the second Ghomeshi matter, you remember, the peace bond that he signed and the withdrawal of the charge, that occurred just weeks before the trial. And that's because Mr. Ghomeshi had done a lot of significant counseling addressing the issues that got him in court in the first place. It's also because he signed a peace bond, and once he had done that, the Crown had agreed that it's not in the public interest to proceed. So, in a nutshell, this is a diagram that explains the process at the Ontario Court of Justice. Craig Penney, criminal lawyer. I'm not your lawyer. This is not legal advice. If you don't have a lawyer, you can consult me. If you do have a lawyer, raise these issues with your lawyer, or you can consult me for a second opinion.